here. Public comment? Any public comment? Anybody wish to comment? Okay. Close the public comment. Approval of the agenda. Have motion, second. All in favor say aye. Those that oppose, no. Motion carries unanimously. Standard department items, discussion, direction to staff, potential approval of settle agreement among the City of Reno Redevelopment Agency, City of Reno, Washoe County School District, and the State of Nevada regarding outstanding property tax increment dispute.
Morning, Sean Oliphant on behalf of the Reno Redevelopment Agency. You have a settlement agreement in front of you, which arrives out of discussions, negotiations the past 6 months between the attorneys for the RDA, the City of Reno, Washoe County School District, and the State of Nevada. This issue was first arrived in August of 2011 when the Department of Taxation questioned whether the treasurer and assessor were allocating taxes to the taxing agencies as well as the RDA properly in accordance with NRS 279-676. Through those meetings, it was determined that the assessor and treasurer had not properly allocated taxes to the RDA and to the taxing agencies in the redevelopment area number 1, which existed prior to 1987. The NRS 279-676 provides that the taxing agencies shall continue to pay RDAs in existence before 1987 the amounts that were being paid to the RDA prior to 1987, which were relied upon for bond payments. The bond payments that the RDA had existing prior to 1987 and the total payments prior to 1987 was $2.7 million. So throughout these negotiations and discussions, there was an issue of whether the $2.7 million is in addition to the increment the RDA receives or whether the increment is part of the minimum allocation. We look back at the legislative history, back to past the 1987, looked at those issues and tried to determine what a court would rule upon, and guess what a court would rule upon based on that statutory history. Through those negotiations, instead of having the taxing agencies pay the minimum in addition to the increment, which would have been a $64 million hit to the taxing agencies and benefit to the RDA, the counsel for each party determined that the best interpretation of that statute is that the minimum of $2.7 million is offset by the increment received by the RDA for those years. So part of the settlement is recognizing that interpretation of NRS 279-676, and if that is the interpretation that is agreed to, there is only 1 year in which the minimum has not been paid, and that was in 2011 and 12 because the tax base fell in the redevelopment area such that there was only about $800,000 of increment received by the RDA. As part of this agreement is the taxing agencies would agree to pay to the RDA in accordance with their proportionate share based on the tax rates, $1.4 million for that payment of the past gap and the increment for 2011 and 2012. The second part of the settlement agreement is the exempt property variance. In 1989, a change was made to the NRS 279-676, which required the assessor and the treasurer to remove property that was transferred from private to exempt status. And the assessor and treasurer's office prior to these negotiations and meetings had not done that, and their interpretation was that the statute says the state or instrumentalities of the state. They didn't consider the city or agency an instrumentality of the state. They subsequently, after we discussed this issue in pre-litigation discussions, they agreed that the city, the RDA, other exempt status are part of that statute, and the base should have been, the assessed value of that property should have been removed from the base. And the treasurer only had information going back to fiscal year 2000 on the fiscal impact if you remove the exempt property from the base that they should have been doing all along. From 2000 to 2010, that's a $4 million fiscal impact to the RDA. So, in other words, $4 million, $4.17 million of tax increment was paid to the taxing agencies, which should never have been paid to the taxing agencies. It should have been paid to the RDA. So part of the settlement agreement is recognizing the fact that that money should have went to the RDA, and it never did. And the parties, the taxing agencies, have agreed to go back 10 years and pay their proportionate share of that. So in other words, the taxing agencies are just giving money back to the RDA, which they had for the last 10 years, which should have went to the RDA in the first place. There's some transfers prior to 2000, from 1989 to 2000, which is at a much smaller scale. But the treasurer has not had information available to calculate what that fiscal impact would be. She's estimated between $500,000 and $2 million. And part of the settlement is we would not be proceeding against those years prior to 2000, partly because the taxing agencies have a statute of limitations argument that it should only go back 3 years. The RDA counsel, myself, believes that we could get past that, so it's a compromise of get 10 years, give up 10 years for that. What the settlement allows to happen is the RDA can, with this agreement, continue to pay its bond obligations that are currently booked for the next 6 years, assuming increment does not increase, just by the way the structured payments go forward. It allows the taxing agencies to pay the share that they were required to pay before and recognize that without putting a fiscal hurt on any of the taxing agencies. So all in all, we've worked to come to an agreement without litigation. We think we've done that, and this board, both as the RDA and for the City Council, would be the first entity who would approve this. This agreement would then go to Washoe County for approval today, as well as the Washoe County School District, and it'd be follow-up with a meeting by the Board of Equalization for the state of Nevada to approve it by the state.
Any questions, anybody? Yes, Mr. President.
Yeah, and I'm not sure if this is for you, Sean, or Robert, because kind of a complex issue for the public, but if this was calculated correctly, Sean, there would be no issue with making the debt calculation, or the bond payment. Is that correct?
At least for the tax exempt portion, it would have had another $4 million available to the RDA to pay its bond obligations. So yes, that would have been paid. Now, those would have been paid going back a number of years. Whether or not that money would still be available right now to pay, I don't know. But there's at least $4 million of revenue the RDA should have received that it did not receive because it was not calculated properly.
I think somehow it's out there that the county is bailing the city of Reno out. We wouldn't be in this situation in the first place if the folks who allocated those taxes did it correctly in the beginning. Would that be a fair statement?
That would be.
And then on the, Sean, part of the settlement is really trying to help the county and the school district and also the city, because we're the different taxing agencies. So what would this provide in particular? I know the council was concerned for the school district. How would this relieve the school district as part of the calculation and the formula?
Well, the school district, if you look at the exhibits, there's payment schedules for the total settlement for each party. The school district is Exhibit B. They have a $1.5 million fiscal impact arising out of these issues in the settlement. They have requested, and the parties have agreed to be able to structure that settlement so it allows payment out over time, so that there's not a fiscal impact directly hit to them immediately. They're going to pay about $350,000 by November 22nd, and then there's payment schedules after that to be made by May 25th, 2013, and then August 25th, 2013.
So this allows them essentially to pay that, what they owe over time.
Right, and I guess another issue is the RDA is not requesting interest as part of the settlement agreement. It's a negotiation. The assessor and treasurer did not calculate this properly, so we haven't gone back and looked at interest, but the taxing agencies are able to pay off this obligation without interest of what they should have paid before.
And then, Sean, this isn't something where we can just forgive the taxing agencies. I mean, certainly we're sympathetic to the school district and everyone else, but we can't do that because of our bondholders. Would that be a correct statement?
I didn't catch the full question there.
So if the council said, hey, we're going to relieve the taxing jurisdictions of their obligation to the RDA, that's something legally we couldn't do because of the bondholders' interests in getting paid. Is that a correct statement?
Well, I don't think we are doing that. We are
No, I'm just saying
getting,
we don't even have the option of doing that.
I can't answer that. That'd probably be a question for bond counsel more than myself. But what I can tell you is we've done our best job to interpret how the statute would be ruled upon by a court and then an appeal 2, 3, 4 years down the road from now. And we've done our best to be able to find out what the court would say, and we tried to agree upon what the interpretations of the statutes would be as we believe it would be by a court. So doing that, I don't think we're giving up any thing that's due to the RDA that the bondholders would be able to say, hey, you've given this up. What we do plan on doing, though, is following approval of this agreement, we will be filing a joint petition if all parties approve this agreement. So jointly, all the taxing agencies and the RDA would file a petition to the court that says, this is what we believe the statutes say. Please confirm in an order, this is what the statutes say. So by that, we'll have an order by a court where this issue will be resolved forever so that we don't have continuing fights about this.
And then one last question, Mr. Mayor. This essentially puts money into the reserve for bond payments in the future on the schedule that Robert gave us, that we would be whole until 2018, assuming there is no increment. So we're allowing some reserves to carry over into the future fiscal years.
Yeah, the guaranteed minimum allocation to the RDA would be $2.7 million until 2018. The reason 2018 is the date is because the original bonds that were issued prior to 1987, those were refunded and reissued in what's called the 1998 F bonds. The payment schedule for the 1998 F bonds, final payment is the first quarter of 2018. So that's the reason it's running through 2018. And the bond payments right now are about $2.9 million per year. This would allow minimum allocations of $2.7 million a year, so there's only a $200,000 shortfall between that and 2018. So it pretty much, it allows the RDA to be able to make their bond payments through that date.
Thank you.
Any other questions, anybody? Mr. Guston.
Sean, just to be clear for me anyway, that when we looked at this initially, if you go back, had the funds been properly allocated back to, what, 79 and 80, at one time we were talking in excess of $60 million. Is that correct?
If you interpret the statute that the minimum allocation of 2.7 is in addition to the increment received, and you took that all the way back, the RDA would receive an additional $2.7 million every year going back, and the total of that would be $64 million. Now, through the legislative history and the discussions amongst council, we tried to determine what the best interpretation would be of that, and agreed in this settlement agreement that the increment is part of the minimum allocation, not in addition to the minimum allocation.
So that's why the settlement is obviously a lot less, because you only went back 10 years, not to the full scope of what we could have gone back to, or at least taken to court and found out which way it would go.
There's two issues. One is the minimum allocation. The minimum allocation, we didn't have to decide how many years we're going back because the RDA was paid 2.7 every year going back except 2011 and 12. So there's only 1 year really where there's increment that didn't meet the minimum allocation. And so that is 1.4 million. That's part of the settlement. The 10 years is the treasurer and assessor should have been reducing the base by the assessed value of property that was transferred to exempt status after 1989. They didn't do that. We can go back 10 years and determine what the fiscal impact of that would be, and that's what we've agreed that the agencies would pay to the RDA to make up for that error.
So the positive is, coming out of this, that now all the agencies understand what the dollar amount is, and what was required to be paid is now settled, or at least we hope is settled after today, and agreed upon for the city of Reno, that we are fined, as you said, I think earlier, for about 5 years, and based on no added increment to the tax base. And that seems to be a very safe period of time. I mean, we're looking at right now, I don't know if it's closed yet, but the post office would be an addition back to the tax increment from where it is, if that's sold to the developers and they move forward with that. So if, again, I go back to, I guess, the lead questions from Councilman Ralston. Sorry, I messed that up. But really what it boils down to, that we're just settling what should have been allocated all along, and is now squared, if you will, up between all the agencies.
That's right. And the second part of this is now the treasurer and assessor are aware of these issues, and they'll be doing it correctly moving forward.
Okay, thank you, Sean.
Mr. Hashef.
No, I think everybody pretty much hit the nail on the head. I mean, I think we need to remember that the treasurer and the assessor came to this council and asked us to work with them early on in the process, recognizing that there had been an error. And but for that error, we would not have an issue with the bonds. And I agree, we just don't have the option to basically forgive the obligation, because that money is due to the bondholders. So I think it turned out to be a pretty good settlement, Mr. Mayor.
Oh, I do too. I think that when the treasurer and they came to us and asked us not to sue, but to work with us, and Sean, I commend you and your staff for working with them and putting this together. If these things would have happened, we had never been in this position anyway. And I thank the county commissioners. I hope they're going to pass this today, and we'll be on our way to making bond payments.
Thank you.
Any other questions? Any other statements? All right. I think I need a motion for approval.
I'll make the motion to approve the settlement, Mr. Mayor.
Mr. Mayor,
Excuse me. Yes, sir.
apologies. For the record, John Shipman. Point of order. This is a settlement that the city and the redevelopment agency are going to be a party to, so we request motions for both bodies.
Okay, so you want me to go with the city council meeting now and then recess, go to a redevelopment?
No. Just two separate motions.
Just
Your
two
Honor.
separate motions, okay.
So that motion was on behalf of the city, Mr. Mayor.
Okay, and I have a second. All in favor, say aye.
Aye.
Those that oppose, no. Motion carries unanimously.
Then I'll make the same motion on behalf of the redevelopment agency.
Same second. All in favor, say aye.
Aye.
Those that oppose, no. Motion carries unanimously.
I make a motion that we never have a meeting at 7:30 in the morning again.
Any other agenda items you want to put on for the future? Having none, no public comment?
Move to adjourn.
Have a motion second. All in favor, say aye.
Aye.
Those that oppose, no. Motion carries unanimously.